Okay, hi everyone. Thanks for coming out today. This is Eric from hrsimple, and we're glad you're here. We have Ann Kendell from the BrownWinick Law Firm. They're out of Iowa. We're happy to have Ann back for her second presentation to tell us about the Employee Handbook. Ann is the author of the Iowa Human Resources Manual on hrsimple.com. So a few quick announcements to run through real fast. Today's presentation will last approximately 60 minutes with some extra time for Q&A at the end. hrsimple.com is an HRCI approved provider and a SHRM recertification provider. At the end of this webinar, we'll give you codes for both certifications to get your credit. You can enter your questions in the chat box and we'll get back to them when we can, either during or hopefully at the end of the presentation. The recording and slides will be emailed to all registered attendees after this presentation. So we may post those up midway through the presentation, but we'll also get them to you by email. So don't worry about writing everything down. We're also posting all of our webinars at youtube.com/hrsimple. So we'll send you that link after this presentation. Okay, so just a bit of info on today's speaker, Ann Kendell. As we said, she authors the Iowa Human Resources Manual, and we're happy to have her back to present again. She's a member of BrownWinick and serves as co-chair of BrownWinick's Employment Law Practice Group. She practices primarily in employment law and commercial litigation. Ann counsels employers in human resources, policies and procedures, unlawful discrimination, harassment and retaliation, whistleblower issues, FMLA, Iowa state and federal wage and hour issues, restrictive covenants, and drug testing policies and procedures, as well as handles employment litigation. She conducts management training concerning drug testing and personnel issues and has served as an investigator for clients regarding misconduct, discrimination, and harassment allegations. Ann represents her clients in front of administrative agencies such as Iowa Workforce Development and the Iowa Civil Rights Commission, and in arbitration, as well as state and federal courts. She has had successful jury trials obtaining defense verdicts on sexual harassment, gender discrimination, pregnancy discrimination, and retaliation claims. Ann has also litigated and enforced restricted covenants on behalf of employers and litigated other commercial disputes. Ann frequently speaks and writes on articles on various employment topics and is a trained and experienced mediator hired by other attorneys to assist in resolving cases. So I'm going to just go ahead and turn it over to Ann, and we can dive into employer handbooks if she's ready.
Hi, everyone. Thanks for the nice welcome, Eric. I appreciate that. We've got this slide posted just to kind of give you a little bit of a roadmap as to where we're headed today. One of the things that I don't hear quite as much as I did a few years ago, but some employers would just say, well, I found some really great, handbooks on the internet that I think would be nice to use. And there are sometimes very good resources that you can find on the internet. One of the issues that we often found is there might be policies that were state specific or policies that were specific to that entity that really didn't make sense for a company. So it's been kind of interesting with the use of the internet and all the resources that we have today that have sort of reinvigorated what employers are looking at as far as possible policies. And sometimes that can also feel quite overwhelming. Our firm represents large employers, but we also represent medium and smaller employers and lots of entrepreneurs who start very small and then grow very quickly. And this is one of the key issues as they're growing, is to figure out what makes sense for their company from the standpoint of the policies that govern their relationships with their employees. So basically, this is just a presentation to help sort out, what do we really have to have, based upon, issues with regard to the law, legal requirements, and legal defenses that we might have if we have those policies. Policies that are very strongly recommended, not necessarily going to be, per se liability if you don't have them, but maybe close, and certainly things that are important for employers to have. And then also point out some state-specific requirements. As I mentioned, a lot of times there can be some, helpful things that you might find on the internet, but it may include state-specific things that you don't need to include, or it may be missing some state-specific things that you do need to include. So I'll kind of draw your attention to a few of those state-specific things that we have found, state-specific topics. So to have that on your radar screen that, hey, we need to have, an HR professional or legal counsel, make sure that we have the state-specific things that we might need. So this is just to help get those items on your radar screen. It's certainly not a comprehensive overview of every single state-specific requirement or topic at all, but just a few sort of hot-button issues that do tend to pop up with some regularity. And then also from the practical side, how do we figure out what makes sense for us from a business standpoint to put in our handbook, and what should be something that is either communicated outside the handbook, or something that maybe we want to put in like a operating procedure manual, management policies, things like that. So we'll walk through some practical ideas about how to assess those things as well. So from the necessary policy standpoint, we have seen more and more government agency investigations, generally speaking. But in particular, if you have an investigation by a state civil rights commission or human rights commission, or the EEOC, which would be the federal agency, one of the things to look at if there's a discrimination, harassment, or unlawful retaliation complaint are the company's policies on unlawful discrimination, harassment, or retaliation. Basically the first thing they ask for to look at. And if you don't have a policy that prohibits those unlawful issues, then automatically you are going to have a problem with that government agency. And they will find that you are already at a disadvantage and that you're already basically kind of on the wrong side of things. Even if the underlying complaint, there may really not have been unlawful discrimination. Perhaps it really was a performance issue, and this was something that was enforced regularly without regard to anyone's protected class or protected status. But just the fact that you don't have that policy, you're already set up for a problem with that government agency. Beyond the government agencies, you also have certain defenses that you can raise, affirmative defenses, if there is litigation by an employee or former employee. If you have the correct policies and procedures, particularly with regard to harassment, you can have some affirmative defenses that can be raised to assist you, and you will not have access to those affirmative defenses if you do not have the right policies in place with regard to this subject matter. So along those lines, what we're saying is we need to have a policy saying that the company prohibits unlawful discrimination, harassment, or retaliation. Some states do have different protected classes. For example, here in Iowa, gender identity and sexual orientation are also included in our protected classes by our statute. And so you do want to try and include all of the protected classes under federal law, but then also look at your state-specific issues. And then you can also have, what we'll call sort of the loophole language and any other protected class or status as provided under local, state, or federal law. And then that helps cover maybe issues that aren't specified that may be covered by your state, or, for example, when Iowa made this change, people had some handbooks in place that had that loophole language, then obviously new changes to the law would also be covered under that type of language. Additionally, on our second bullet point, requesting reasonable accommodations for disabilities or religious beliefs, that will be another issue that would be important whether you are having a government agency review your policies because of a complaint, or if you do have litigation. If there are no mechanisms by which people are advised as to how they are to raise those issues, you're going to automatically be at a disadvantage. So that's an important piece. And then to the third bullet point, and this one, a lot of employers, definitely get the first bullet point saying, we don't allow discrimination or harassment. Sometimes employers don't think to put that last category of retaliation in. More and more employers are doing a better job with that, and that's good, that's important. Retaliation claims are by far really mounting and increasing and becoming more of a focus, whether it's private litigation or government agency action. And that's in part because, it's a natural human instinct to be angry if you've been accused of discriminating against someone or harassing someone. Even if you did not do that, you can still be angry. Perhaps you might be more angry if you are innocent. So the point is, retaliation claims are really a serious issue. And so I do think employers are doing a better job of including that in their policies, prohibiting that type of conduct. But one thing that sometimes can fall through the gaps, along with that retaliation piece, is actually how to report, how to make that complaint about discrimination, harassment, or retaliation. We'll have a policy that says we prohibit that, but then what do we do about it? So we want to make sure that we have all of those bases covered because it will be important to you, like I said, whether you've got a government agency looking at your policies or whether you actually are involved in litigation. And then along the lines too, with regard to the complaint reporting process, make sure that there is kind of what I'll call the escape hatch. So it's not just that a person is locked into reporting an issue to their direct supervisor, because the direct supervisor might be the guilty party or the one who's being accused of something. So if we have only one route for an employee to make a complaint, and that route leads through the person who is going to be the accused harasser or discriminator, that basically undoes the value of having that policy. So make sure you have multiple avenues for complaints for employees so that they can raise those issues. In addition to just the legal issues and legal protections and possible affirmative defenses that you can have with these policies, just from a practical standpoint, it's important to know that these types of things might be happening in your workplace, because you cannot fix those problems if you don't know about them. So, I don't just say this from the legal standpoint and only defensive standpoint, but also from the, preventive standpoint. These types of situations are messy, they're distracting, it takes away from what you're trying to accomplish, at your business. And so to avoid them in the first part is good. If it's happening, to have someone report it and get to the bottom of it is also good. And then, as I've noted, we've also got our defensive reasons as well. So there may be some other necessary policies based upon your particular business. Are you large enough to be covered by the FMLA? If you are, then I think it makes sense that you have an FMLA policy. Providing that information to employees is important, because if they are not advised of their FMLA rights, that's going to be a problem for you. If you are a federal contractor or subcontractor, which can be kind of a more confusing question than employers realize, particularly on the subcontractor piece, because if you are providing something to another business who is taking your widget and putting it in something that they build for the federal government, you could be what we call the unwitting federal subcontractor. If you fall into that category, there are some specific policies that you need to have as part of the compliance with regard to, obviously, an EEO policy, disabled people, veterans, things like that. So there are going to be some additional policies, as well as special postings that would be involved if you fall into that category. And then, do you conduct drug or alcohol testing of employees? If you are doing that, in particular, if you have CDL drivers, the Federal Motor Carrier Safety Administration regulations require a written policy. Now, sometimes those can be standalone policies. For example, if not your whole workforce are CDL drivers, and you don't want everyone to have that, you could have a standalone policy or a separate handbook that is just for those CDL employees. That's up to you. I don't think there's a problem to have it in a general employee handbook, but specify that that policy applies to just those specific employees. So there's some decisions that you can make in that regard. There are also a lot of state-specific laws. In particular, Iowa has a state-specific code on private employer drug and alcohol testing of employees, and that also requires a written policy that's provided to applicants as well as employees. So there will be possibly some state-specific issues along those lines if you do that type of testing. One thing that has come up recently with many states allowing, medical marijuana or just allowing marijuana use for, recreational purposes is what happens for, employers. Well, marijuana is still illegal under federal law. And even with the states that have allowed, medical marijuana or recreational use of marijuana, most of those state codes have carve-out provisions that allow employers to still disallow use of, drugs in the workplace. So there are still going to be, some protections for, employers to be able to say, we don't, we want a drug-free workplace, that sort of thing. Really the only issue that you could have in that regard is if someone is using, medical marijuana, and that's allowed under state law, then what you would want to do is treat that like you would any other prescription drug and see if, the person is safe to perform their work while using that lawful drug. But anyway, those are some additional issues that could require necessary policies based upon your business and the types of choices you make with regard to whether you sell to federal contractors or the federal government or do that type of testing. So these are the strongly recommended policies, and I will tell you, along with we've seen a lot more EEOC involvement with employers. We used to see more state agency involvement on discrimination issues. We've seen more and more with the EEOC. We've also seen a huge increase with Department of Labor investigations. So along those lines, the first thing the Department of Labor is going to look at are your policies on, how time is reported, how PTO is handled, that sort of thing. So that's where these strongly recommended policies with regard to reporting time, that's what's triggering that, along with the fact that I think it's helpful for employees to understand how that works. So we start with handling of PTO, and that can be, depending on how you have it set up, it could be, vacation, sick time, personal time, whatever you want to call it. You're going to want to explain how that time, is it prorated throughout a time frame? Does it accumulate? And are there ever times where it can be forfeited? For example, if you have vacation and you have to use it or lose it, by the end of the year, those types of things. I also want to draw your attention to the fact that there are some state law requirements with regard to, in particular, vacation time. I know in Illinois there are very strict standards on forfeiture, and they really don't want, they really don't want employees to have to forfeit, accumulated vacation. So there can be some state-specific issues there too. So that one is important, but you also want to make sure that you've got it right. So you want to definitely have an HR professional or attorney check that for state law compliance. Reporting absences and consequences. Not only is that helpful for employees to understand, that also can be very helpful from the standpoint of unemployment insurance. If you've got a 3 days no call, no show policy, that can be helpful then if that occurs and you're trying to fight a claim for unemployment, in addition to just them understanding that that's a consequence. Obviously, safety issues. We want to make sure that employees are, reporting workplace accidents, illnesses, and then also, as I mentioned before about retaliation on the civil rights standpoint, retaliation is becoming a hot issue across the board when it comes to employer-employee relations. So we want to make sure that employees know they need to report things right away and that they will not be retaliated against. Doesn't mean that they are protected from, performance management, but they also need to know that, that they should report those things and that we're not discouraging that. So again, as I mentioned, the Department of Labor is really focusing in on pay and hour, wage and hour issues for employees and how time is being calculated, in particular if there's some off-the-clock work being done. So one of the things that we have really focused on is making sure employees understand, it's your obligation to report all hours worked accurately. Affirmatively put that on employees. You need to do that. You need to report all of your hours. And then we also want them to understand how they submit requests for reimbursements, not only from an administrative standpoint, but if there are things that are not going to be allowed or if they are doing this in such a way that it might keep the expense from being reimbursable, it's important to outline those issues. Wage complaints are very sticky complaints. A lot of states have wage payment collection laws, and it punishes an employer for not paying an employee wages that are due and owed. And of course, there's the Fair Labor Standards Act issues under federal law, but there are some real state specific items that can be problematic. And so making sure it's clear how things are to be done and what the employer will pay and how that's going to work is important. Now, the second bullet point is one thing that the Department of Labor really likes to see, that there's an employee obligation to complain about a supervisor who's requiring or encouraging the employee, to work off the clock or some other, pay violation, and that the employee is not going to be retaliated against. The DOL is very much looking at what is sort of the wink, wink, nudge, nudge that's going on in workplaces where a supervisor loads up employees and says, this is the work that you've got to get done and it's got to get done this week, however that happens. And by the way, we don't want any overtime. So, the ways that employees are feeling this pressure to work off the clock or, some other issue like that, we want employees to make sure that they're advising people higher up the chain what's going on and make sure that they understand that they are not going to be retaliated against. What can be somewhat difficult too, you think reporting time is, well, it's okay, you punch in, you punch out, what's the big deal? Well, with the use of cell phones and remote access, people can be, whether they're being encouraged to or not, doing a lot of work off the clock, where they're checking email at night and that sort of thing. So we want to, make sure that we are being clear, what expectations are as far as when, people should be working, and if they're, working off premises, that they need to be reporting that time. There are also, possibly some issues with donning and doffing, and sometimes there are some specific punch-in and punch-out procedures. So if there are some things like that that are, kind of specific to your workplace, it may make sense to have that in a policy. But I would be very careful that you make sure that your policy is accurate. Because even though we, sometimes want policies to make things clear and we think we can maybe use it, as evidence if we're ever investigated, it also can memorialize wrong procedures and be evidence against us. So it's very important that you have, legal review on those items to make sure that if you have that policy, that it says the right thing, under state and federal law, as well as accurately communicates what your expectations are. More strongly recommended policies. This slide is really more with regard to protecting the employer's interests. If you have confidential or trade secret information and you want to protect that, the measures the employer takes to protect that information is going to be very important to a court in deciding whether that information really is confidential or trade secret information. Because if you have not taken the steps to protect it very well, the employers or the court is not even going to think that the employer really treats it as a trade secret or that it's confidential. So the measures that you take for protection, hopefully stop any leak of that information or improper use of that information, but it actually can cut against you in a legal argument to establish that the information is even information that can be protected by the courts if you haven't protected it adequately yourself. So that's an important piece. It's good to have those policies in place in a handbook, but because we don't want our handbooks to be considered contracts, if there are especially employees who are very involved in your most highly secret information, it's probably also a good idea to have separate agreements with them that specify what their obligations are and what the consequences are. But also having generalized policies in the handbook is a good idea. But like I said, if you want to enforce contractual obligations, that's another layer of protection that can be helpful, like I said, particularly with the employees who actually have access to that. Courts don't love to enforce agreements against employees who don't really have access to those types of issues. So use some discretion when you're deciding who should be under that type of an agreement. But like I said, a generalized policy on this is another layer of protection and can be helpful. And then prohibitions on outside work or conflicts of interest. In particular, if you've got someone who is injured and off work and perhaps has a work comp claim, and suddenly you notice that they're doing work somewhere else, that can be a little frustrating to an employer. Or if they're off on FMLA leave and you find out that they're working somewhere else but they're still on protected leave from your company. The problem is if you don't have any prohibitions on that, and what they're doing is within their doctor's limitations, that may not be an issue at all that you can do anything about. And then, of course, if there's a conflict of interest with regard to, the employee's, personal interests, or if you do allow some outside work, but not if it's a conflict of interest, you want to make sure that you, have put that forth, because finding out after the fact, I mean, you can implement a new policy, but, it's a little bit hard to, when the horse is already out of the barn. So also another quick point too on the trade secret information. Most states follow the Uniform Trade Secrets Act language. There are going to be some state differences, but most states do follow that language in their own state Trade Secrets Act. But then in addition, recently there was the Defend Trade Secrets Act, that is a federal law that was passed, that allows for protection under state and federal law, and then even allows additional damages for a company that enforces against someone who has taken or misappropriated their trade secrets. But one of the other things that you would need to have the protections under that federal law for these additional damages, you would also need to have a whistleblower policy that basically says that that employees who are blowing the whistle are not going to be in violation of your trade secret policy, that sort of thing, as long as it was important to what the issue was that was being reported. So if you want to have those additional benefits of that new federal law, you also need to make sure that you put in an additional protection there, because the government does not want whistleblowers to feel like they're being stymied at all from blowing the whistle on issues, because they're afraid of being sued on a violation of the company's trade secrets policy, that sort of thing. So, but that also would be something that you would additionally put into a separate type of agreement with someone who is actually handling those types of that type of information, or has access to that type of information. So I've kind of, as we've been going, talked a little bit about some common state-specific issues as they come up. Another one is pregnancy and maternity leave. States oftentimes have their own specific laws on those issues. Jury duty, if that is, usually in most states it's protected leave. Some states, allow it to even be a paid type leave. In addition to jury duty, some states even have, paid witness duty, or at least have protected leave for witness duty. Veterans Day leave, that can be a state-specific issue where someone can have the day off, either paid or unpaid from work. But for example, like in Iowa, the veteran would need to request that leave at least 30 days in advance of Veterans Day. So there's some state-specific issues like that. Firefighter and EMT issues. If someone needs to, leave work because they're, volunteer firefighter, EMT, et cetera, and how that is handled by the employer and what the employer can and can't do. A lot of times there are some state-specific laws regarding that. And then smoking. Now that sounds like, well, you know where you can smoke and not smoke, right? Well, for example, in Iowa, we have the Iowa Smoke-Free Air Act, which disallows smoking in most, there are a few carve-outs, but most establishments that have enclosures of 4 walls and, floor and a ceiling. And it also provides that people can raise violations of that law and not be retaliated against. So, for example, an employee who knows that a coworker is, smoking, either inside the building or somewhere they're not supposed to be, for example, like a company car, that sort of thing, and reports it, that they can't be retaliated against. That's, like I told you, retaliation is really gaining ground pretty much everywhere. So along with, for example, Iowa's Smoke-Free Air Act, the prohibitions under that act need to be provided not only to employees but applicants. So, like I said, there can be some real specific type issues with regard to some of these categories that may seem, kind of common sense, but some of them might catch you a little bit off guard. And then, as I noted, some states, obviously have, some drug and alcohol testing specific issues. I mentioned, earlier the marijuana issue, although generally speaking, the employer is not going to have too much of a problem with that because of, the fact that it is still legal under federal law. So one of the things that I, oftentimes, will hear, especially from, a newer company, is, well, I don't want to be painted in the corner. I mean, if I put things in this handbook, it makes me nervous. I mean, what if I want to change my mind, or what if I don't, like it a year later, that sort of thing. And I will tell you that is a valid concern, because, you shouldn't just put out a handbook to have one. And I don't see that a lot, but I have seen that sometimes, where company puts together a handbook and they give it out to all their employees and they place it on the shelf and no one thinks about it again. And sometimes there are things in there that they don't end up liking, or they didn't really understand it when they had it in there, and it causes a problem. And that is true, that if it's in your handbook, it's kind of your word, what you say you're going to do, it can be used against you. So I would say, if you don't have the staff resources to, enforce a comprehensive handbook, keep it simple. Sometimes, when we've got an entrepreneur that's just, getting started, do I really need a handbook or not? Sometimes you do, sometimes you don't. I do think it's helpful, especially, for example, like in Iowa, once you have 4 employees, you're covered by our state civil rights laws. That at that point, then you definitely need to have, discrimination, harassment, retaliation policies. You can have a very, small handbook that just hits some of the key things that are important without just loading it up with, policies that sound good, but, we're never really going to need or use or enforce. So how do we figure this out? How do we know what we need? Well, I have employers talk about what are the key things that employees need to know about how the company operates. And that can be, from a production standpoint, it can be from, an operational standpoint as to, hours, et cetera, if there's different shifts, things like that. And then, after we kind of think through those things, then I want them to assess that list and say, okay, is this something that could change or will change in the near future? Now, the reason that I do that is most employers do not love the idea of changing their handbook every single year or, 6 months later. So I have them assess that. And then the items that change is expected or it's possible can be part of a standalone policy, or it could be a company memoranda that's posted or available to employees on on intranet, that sort of thing. And then we can have the handbook be, the information that's more likely to be constant as well as important. So you can have a handbook and you can have standalone policies that are for all employees or a company memoranda. Make sure, though, that the employees who need to see that are provided notice of it, and or provided the actual document itself. If you like to do like an intranet type situation, then that's fine, but then you need to make sure that employees are aware that there is a new, new information on your intranet, that they know to look there. Because we can have an intranet, but if no one knows that anything changed on it, they might not necessarily discover it, and that it will be on the company to make sure that employees are aware that there has been, some sort of change. So you can have, different pieces like this. And then, as I mentioned earlier, there are some items that, might be better suited for, management-only policies that we want our managers to know, but that's not necessarily something that, we need to or want to broadcast to the general employee population. So what are the types of things that generally change? Well, compensation. Now, obviously, that's individual, to employees or different levels of employees, but then also along with that could be if you like to have the possibility of, doing bonuses, things like that. That all is subject to change. So you want to be, careful about memorializing that in a handbook because it could change, and you don't really want to have an employee pointing to a policy saying, hey, I'm supposed to have, a cost of living increase every single year or something like that. Employee insurance benefits. There's kind of two issues there. One, you may change your mind on, whether you're, providing, life insurance, et cetera, or the insurance benefits themselves may, change. And the language in those policies are really what govern those benefits and how they work. So, you can make some generalized statements about, the employer provides, benefits that, may change, et cetera. But, I would not really want to memorialize that too much in the handbook because I do think, getting into the specifics, you're just ripe for having to either change your handbook or having a handbook that's not consistent with what's actually being provided. Safety procedures and rules. Now that sounds a little strange, like, well, isn't that important? Well, it is important, but you may have changes to it. There may be things that, you learn that are better. There may be technological changes that, make things different or better. So not that I don't think those things should be memorialized and trained upon, they should. But that might be something that changes a little bit more than you want to be changing your handbook. So I think that would be a better item that, would be more in line with like a standalone policy or posting, something like that. And then, of course, as you do trainings, you can review those things as you're doing that. And then other procedural operational items. We run things today this way, but, you may have a change in, your product line. You may have a change, you may have a reduction in force that, now you don't have, 3 shifts, work 24 hours a day, things like that where, there just might be changes to how we do things. You probably don't want to include those in a handbook unless you're really wanting to change that with real regularity, which most employers do not. Now, when we do have a handbook, say we roll out our new handbook, and 6 months later we notice, oh, I probably need to, tweak this. You can do a memo to make that change and make sure employees are aware of it. Like I said, if you put it on the internet, that's fine, but make sure that employees get notice that there is a change. But you also want to make sure that you keep track of how your policies have grown. So at any point in time, you need to be able to look back and say, here's what our policy was on X date. And then when that policy changed, we know there was a new handbook or there was a memo that went out, et cetera. So you need to keep track of sort of the chronology of your policy changes. And one of the ways, too, as we see needs for changes in policies, is I will keep kind of a handbook that I call sort of the draft for next time. And then, we'll either make notes or whatever to show here's what's working, here's what's not working. So next time we want to make a change in this way. However you want to do it, that makes sense for your operations, that's fine. But the point is you do want to keep track of, what policy was in place at what time and what changes do we need to make and when did those changes occur. Another thing that I have had some success with employers that have policies in place, handbooks in place, and they're getting ready to do a new handbook, is we will talk to the management team, the ones who are kind of doing the, hands-on management supervision of the employees, and get an idea of what's our most violated work rule? What are our most common problems? What are rules that are hard to enforce? What makes sense, what doesn't? Along with like job descriptions, things can grow and do grow organically. So if there is something that made sense when we rolled out the handbook 2 years ago, but due to whatever factors doesn't make sense now, your managers are probably going to have a good handle on what those things are. And so getting that information can help you make good changes to the handbook that make things more manageable for everyone, the employees as well as the supervisors who are enforcing those rules. One example that I have is I had an employer that had in their call-in procedures that you could not send text messages. And as it turned out, a year or so later, most of the managers were allowing people to use text messages, and it was easier for the manager to allow that. So we, had an issue where, someone had kind of done a no-call, no-show type situation, and there had been a text message at some point. And while that was technically a violation of that employer's rule, the practical application was that manager and other managers had been allowing that type of reporting. So, we went back and made that change, that is allowable, but then of course, to, make it make sense, that it has to be, more than an hour before the shift or something like that, unless it was an emergency. So that's just kind of a small example. Another common question that would get or concern is, does identifying work rules and the level of discipline, restrict the employer's ability to discipline employees? Meaning, if this is the list I've got and they do something that's not on the list, can I still talk to them about it? Or I've got kind of a progressive discipline policy. We start with a, oral counseling and then a written counseling and then, different levels of discipline. Am I, locked into that? And, that's also a good question. Now, outside of a collective bargaining or other employment agreement, identifying work rules can be helpful in establishing expectations, and then to address being locked in. Remember to note in the policy itself that the list is not exclusive. So, this isn't the whole, list of awfuls that you can, commit while you're an employee here. But here are things that we definitely say are not okay, like punching in for someone else, falsifying, time cards, obviously, harassing someone, or other unlawful behavior, safety violations, things like that, real important issues. It's not a problem to list those out, but do note that the list is not exclusive. And then as far as, progressive discipline, I think a lot of employers find that it's helpful to kind of explain, here's how this works. But I always am quick to remind them, but make sure that you also state, the company reserves the right to implement any level of discipline at any time in its discretion. So, someone has never been in trouble, but they commit a big problem in your workplace, you can fire them right away. You don't have to, go through the whole litany of progressive discipline just because they've never been in trouble before. And I think it's helpful to just make that clear in that policy. So it's fine to outline that, but just make sure you put that caveat in so that employees know that that's how it is, and that you can certainly point to that language if someone questions you about it. And then also the language in the handbook, and if you've got like a signature page, the acknowledgement page for the employee, it's good to reflect that it's the at-will status of the employment relationship, that's what governs. And again, this would be outside of the collective bargaining context or an employment agreement that is maybe a for-cause termination and not an at-will employment relationship. But most employees, or many of them, are going to be, of the at-will status, and reflecting that in the handbook as well as where they sign on the dotted line is helpful to just formalize that, make it understood, and then, like I said, if you have to point to this in defense of anything, you've got it. Another practical issue to think about is if you have, an employee population where many of them speak a different language as their native language, you may want to consider having a handbook in that language. You'll have to evaluate how well your employee population speaks English, reads English, understands English. If they don't understand it very well, then I think that's, a good sign that maybe you need to have, policies in their native language so that they can understand, what you're saying. Along with this, there are postings, required employer postings that you can have in other languages. And so if you go onto the federal government websites, they're really helpful resources. The EEOC's website, the Department of Labor's website, they will have postings that are in other languages, and you'd be surprised how many different languages they have for those. So that's, you don't necessarily have to pay for those things. You might be able to find them online. So I'd recommend that you take a look at that, because it is important, in particular with the policies that we've discussed today, particularly discrimination, harassment, retaliation, making sure that employees, understand, their rights and their obligations with regard to those things, as well as safety issues, pay issues, etc. And then I kind of touched on this a bit earlier. Keeping prior versions of the company handbook in case you have litigation in the future. And I know that sometimes you think, well, but we changed. We wanted a new handbook, and maybe it's not just because we had changes in how we did things. Maybe we, didn't like that or thought it might have been a little bit of a mistake. Isn't that a problem for us? Well, it could be, but, I think the bigger problem is if it looks like you destroyed evidence. In litigation, there is the other side who's opposing you can ask for what's called a spoliation instruction, which means the other side destroyed evidence because they thought it might be harmful to them. And so if there's any doubt about what was in that document or in that piece of evidence, all inferences should be read in our favor, Judge, because they destroyed evidence and they should not get the benefit of that. And judges are inclined to allow those types of instructions to a jury, that if something's missing and one side got rid of it, that they can infer that there was a problem and that's why they got rid of it. The other piece of this is, if people have copies, so you might as well just have it yourself, and that way you know what it actually said, what it didn't say, and you can understand sort of the chronology of the changes that have been made and why you've made those changes, and showing that you have improved upon things is usually pretty helpful, particularly when you're working with the government, or if you do find yourself in litigation. It shows that the company is working in good faith to improve things. But more importantly, like I said, you can have consequences to not having those. And I also, like I said, things always surprise you. So someone probably has a copy somewhere, and then you don't know if that really is the right copy, or if they doctored it a little bit, or if they did and you don't have a copy to show that it was, that's going to be a problem for you. So don't be afraid of keeping those. In fact, I think it's a good idea to keep them, because that way you know what you're dealing with, and you can understand and see the changes that have been made and when those were made. So let's see. We've got just a couple of minutes. If folks have questions, please feel free to submit those. I also am going to talk a little bit more about management and what I'll call kind of operating procedures, in particular with regard to handling some issues that are covered by law. So, for example, we talked a little bit about the FMLA earlier. We talked a little bit about requesting accommodations under the ADA, and also religious accommodations, things like that. Sometimes there can be a breakdown between higher level management and the supervisors that are out there actively supervising the general employee population. And it's not that those managers are bad people or anything like that, but for whatever reason there can be sometimes a gap in communication and training that occurs where we've got people in HR or the upper level management that know and understand how our FMLA policy is supposed to work, or know and understand how the company handles reasonable accommodations or requests for reasonable accommodations, that the frontline supervisors, the message does not always get transmitted down. Sometimes it can be helpful to have sort of standard operating procedures or management policies that touch on those specific issues. It also is helpful to train those managers on those issues as well. Sometimes people are asking, or they're either putting you on notice that they have a health issue that could be FMLA qualifying, or they are asking for a reasonable accommodation and they don't use those words. If we don't equip our frontline supervisors with that information, then we are leaving them, without key information that they need to be able to pass along information to us, and we're putting the company at risk because we're, basically allowing a block to be put, in that communication flow. And we've seen that in particular with FMLA cases, but also usually it's a health-related or physical type issue. So we want to make sure that we are getting that information, throughout the managers who could be receiving those messages. So someone who's saying, oh gosh, man, this would be so much better if I had a, standing here would be so much better if I had a rubber pad underneath my feet. An on-site manager could take that as, oh yeah, that'd be great, wouldn't it? And maybe that person is actually making a reasonable accommodation request. So, kind of equipping those managers with that information to even just troubleshoot or spot potential issues, and to forward that, those people to HR or whoever handles those issues for the company, can be very helpful. And like I said, that can be in standalone policies that your managers can look at, in addition to training, however you want to handle that. But that is one key area too, that you may have a set of policies that make sense for managers that don't necessarily, it's not necessarily what you transmit to the whole employee population. So I did want to touch on that at least briefly here at the end. Let's see. Don't know that I am seeing. If there's questions, please make sure you submit those. I don't know that I see those, but if we get any.
Yeah, and we do have a few questions. I thought I was sending those to you, but I apparently wasn't sending them in the right place. I can just read through a couple. I thought I was sending them to you, but apparently I wasn't. But I have them all written down. So I can just toss them out to you, and you can answer them quickly as best you can on the spot. Does that sound good?
Sure.
Okay. So we just had one come in from Marin that says, where can we find state-specific information regarding visa issues? She's in South Carolina. Where would she go? A lot of the states have pretty decent websites where you can do a word search with regard to the state codes. Another thought too is this, it sounds a little counterintuitive, but I have had good luck just if we've got a client out of state, sometimes we'll start by calling their, labor department, like in Iowa, it's Iowa Workforce Development or the Iowa Civil Rights Commission or, whatever. But you can, try calling some of the government agencies and say, I'm trying to make sure that, I'm compliant with our state laws. And so, do you have some guidance on, do we have code sections that deal with this, this, or this?
And you'd be surprised, a lot of them they can be very helpful. But usually most states do have their state code, an administrative code, or their state regulations. So there's state laws, but then there might be kind of interpretations that are state agency regulations, or like in Iowa, we call it our administrative code, that are word searchable. And so I think you can have some good success there. They try to generally break down, the code sections and the regulations by topic. So you can also look in the index online, and hopefully that should be helpful too.
Okay, thanks. Another question from Kathy. What policies are needed for Fed contractors? We are a financial institution classified as a Fed contractor, or maybe where she should go to get that info.
Yes, and she's right. So the OFCCP does have specific requirements. And there's not only policies, but there's also an affirmative action program requirement that is a little bit more comprehensive. But I would just check, the federal government website, OFCCP. Basically, quite honestly, Google that, and it should take you to the right place. And then it's very well outlined. What are the different requirements. And usually there's some real helpful links that, from that website that you can click on those and find, what it is that, that your institution's supposed to do.
Yeah, and I'll quick plug for hrsimple. We have the Model Policies and Forms resource, or the Human Resources Manual. We usually say the Model Policies and Forms, check if your state has that on hrsimple. That's a good resource to get all of the information about employer handbooks and different policies and stuff like that.
Absolutely.
Another just general question from Deanna. Can the employer require the employee to turn in their employee handbook upon terminating them?
Yes, you can, unless there is some specific state law in any state, and sometimes they can be kind of unique. But generally speaking, if that is something that you treat as company property, you can, but you want to have that be something that you state in your employee handbook as well. What really becomes the bigger issue is practically enforcing that. What are you going to do if someone doesn't turn it in? If it's something that you treat as kind of a confidential or trade secret type information, you could have some protections there. It kind of depends on what's in your handbook, but yes, you can attempt to do that. Like I said, unless there's most states, I don't think that is an issue, but I do not practice law in every single state in the union. So there's always, the possibility that there could be some strange, unique quirk out there in some states' law. But as long as if it has the level of trade secret protection, then you should be able to definitely. Otherwise, it would just be a matter of kind of the expectation of the employer, and make sure that you have that in the handbook. Like I said, then the real practical issue is, how far do you go to enforce that? But you certainly can attempt to, like I said, unless there's some strange quirk under some states' law.
Okay, thanks. Ann, can you just go ahead and flip to the SHRM and HRCI codes in case anybody needs to get out of here and get their codes? Just flip forward on that slide, and we can just keep running through a few questions. Thanks.
Great.
Oh, if you have a group of Spanish-speaking employees, are you required or should you have a handbook in Spanish in addition to the English version?
I would, I mean, if you can, if it makes sense from a financial standpoint, if that's not too burdensome, I usually recommend that employers do have a version in Spanish. It's, it can be real helpful from a practical standpoint, but then also from, sort of these required and strongly encouraged policy standpoint, making sure that they understand that information. I think it can be real helpful. And in particular, if there ever is an issue where you've got like the EEOC taking a look at what's going on in your workplace, they will absolutely want you to have those in Spanish, especially if there's, kind of a significant amount of Spanish speakers in the workforce.
Okay, we'll do maybe 2 or 3 more questions if that's okay with you, Ann.
Sure.
Is that good? Okay.
Sure.
I think that's about what we have. This one's from Kathy. Is it okay to just post the EE handbook on the internet or intranet or a drive that can be accessed by employees without creating a hard copy for each of them?
You can do that as long as every employee is able to access it, and that they have noticed where that is kept. And then if someone wants to print a copy of it, I think you'd probably want to consider allowing them to do that if they wanted to. But yes, you can have policies on like an intranet or however they can access it, as long as all the employees can access it. And I would still get some sort of acknowledgement that the employees were told where it is, how to access it, that sort of thing, and have at least some written acknowledgement in their personnel file showing that they were told that. And then if you make changes, you're going to want to send out a notice that there's been a change made, so that they're on notice that there is a new change, and that way they can access it and take a look at it. But yes, you can have that as long as it's generally accessible.
Okay, cool. One more question here. If you make changes to a policy in the handbook and do a memo, would you recommend having the employees sign a document that they have been made aware of the change of policy? We only have 15 employees.
Yeah, with that, yes, I would. Since it's not too hard to get 15 signatures, I would recommend that. That would make sense to me. If you have a larger employee population, perhaps just sending out an email to all of those email addresses saying there's been a change to this policy, et cetera, then you still have a paper trail showing that they've been notified about it. That could be, if you have a larger employee population, that might be a more efficient way to do it. But with a smaller employee population, I like to try and get written acknowledgments on those types of things when we can.
Okay, yeah, I'm not seeing any other questions. Ann, can you go ahead and flip to the last slide just so they have our information? I know there's restrictions sometimes with out-of-state, because Ann's in Iowa and licensed to practice there. So if you're in Iowa, definitely get in contact with her. For the other stuff, either refer to us or to Ann. One way or another between the two of us, we'll try to get you help if you have any further questions. As I said, the model policies and forms resource we put together for individual states is a good one. The Human Resources Manual, which Ann writes in Iowa, is another good resource that some of those will address employer handbooks, employee handbooks as well. So take a look at those. If you're interested in the model policies and forms resource specifically, I don't know if it's available individually on our website, but you can also, if you have a pen, write down the number 866-439-2227. I'll include info in the follow-up email, but that's just, you could call in and get that resource specifically, because I think it does have applications to this webinar especially, and it's a really good one. So with all that said, Ann, thank you for coming on today. We really appreciate having you again, and great presentation.
You're very welcome.
Do you have anything else to say for everyone who's stuck around so far before we go?
I don't think so. One of the key things is just making sure that everything, communicates how you want it to be communicated, and then of course just double checking to make sure that you're, in compliance with state and federal law, and otherwise you should be good to go.
Okay, great. Well, thank you again. Thanks to everyone who stuck around and came out and listened today. For hrsimple.com and BrownWinick, thank you for attending.